we need to get organised. So it's a Planning for Later Life seminar. The format for today is going to be a quick talk from myself, from Allan Janes, Kate from Eximius Care, and then Duncan from Credit Financial. The whole theme is around steps you might want to think about when it comes to planning for later life. A few pointers, tips, and then there's time for questions. If anything does come up as we're going through, obviously do ask. And we'll have a space at the end for obviously while he's going around ask any questions that you do have. So first of all, I'm going to be covering from a private client lawyer's point of view some of the steps that you can be taking or thinking about when it comes to planning for later life. Three main topics we'll be covering is lasting powers of attorney, how they operate, why you might want them, wills, some specific types of wills that are catered specifically to forward-looking and late life planning, and gifting the next generation from a inheritance tax point of view, how that operates in some of the limits of later life. So, lasting powers of attorney. Some people are familiar with these, some people aren't. There are two types, one that deals with property and financial affairs and one that deals with health and welfare. The principle behind lasting powers of attorney is this document you put in place while you have mental capacity, nominating individuals who can make decisions, take actions on your behalf, either when you lose capacity or in the case of the financial one, while you have capacity on your instructions. You have to have capacity to make a lasting power of attorney, and its authority ends at your date of death. That is something people often overlook. The financial power of attorney is the one that people tend to be more familiar with, and what it does is it allows you to nominate someone who can deal with banks, deal with the sale of your house, any professional advisors on behalf. That one in particular, as I said, you don't have to have lost capacity for it to be used. You can ask your attorney to make decisions on your behalf or act on your instructions, but the authority continues should you ever lose capacity. The health and welfare one is slightly less well known. That allows your attorney to make decisions in relation to where you live, medical treatment, life-sustaining treatment, dealing with care providers, the NHS on your behalf. Because of the type of decisions that are involved, obviously, can only be used if you do not have capacity to make decisions like that yourself. But that being said, it is invaluable if you do ever find yourself in a circumstance where you lack capacity and are having to deal with individuals or your family are more specifically for those sorts of things. So, who can you appoint as an attorney? In short, anyone, as long as they're an adult and they are not bankrupt. That is one restriction. Financial powers of attorney in particular, bankrupts can't act, but they can do something welfare. So, it's usual for people to appoint family and friends, and very common actually for people to appoint their spouses, because as much as the myth exists that next of kin can make decisions on your behalf if you're not able to, these days in particular, it's becoming less and less true. Financial institutions will protect themselves by ensuring that they're dealing with someone with the correct authority, and the lasting power of attorney is the way that they can prove that. So you can often find that next of kin think that they do have a right and ability to make decisions with care providers or banks on your behalf, and they simply can't without the authority. It's also possible to name professional attorneys. It is something that we do. We only tend to do it where there's no close friends or family that are suitable to act or able to act for some reason, or for people who have particularly complex affairs and want to know the professional is managing those affairs for them. Yeah, always welcome to do it. Obviously, a charge attaches to that, so it's worth bearing that in mind, but sometimes it is appropriate. And the last point I put on there is to do with trust. So, regardless of whether it is friends and family or professional advisors, you have to have explicit trust in whoever it is you're nominating as an attorney. You're handing over a lot of authority to do with your finances and your well-being in some cases. If there's ever a question as to whether or not you do explicitly trust that person, don't appoint them. That's sort of an immediate red flag for us, so straight up. Two specialist topics when it comes to lasting powers of attorney. So, Lasting powers of attorney, you can do them yourselves. The documents are freely available online, and I'm a big advocate for them actually. So rather than our fees ever be the thing that stops you from doing them, definitely have one that can do them. But there are a couple of points where it's worth getting a professional to draft them on your behalf because it covers some slightly more complex things. So first one is discretionary fund management. As a rule, attorneys are not permitted to delegate their discretion to anybody else. And that really does come up quite frequently with people who have investments, and those investments are managed by discretionary fund managers. If that is the case, the attorneys are not authorized to do that. They have to bring the investments back under their own control. So to circumvent that, you can specifically include authority in a lasting power of attorney. That means the attorneys can continue to place funds with discretionary fund managers or actively look to do so, which is quite a useful IHT planning tool in a lot of cases. Business property relief schemes and investments are almost always discretionary managed because they tend to be aimed at share portfolios, so slightly higher risk. But it's a very quick thing to get the size of your estate and tax purposes reduced. Business interest is the other specialist topic, as we call it. You can, through a lasting power of attorney, give attorneys authority to manage business interests on your behalf. When we're including those in powers of attorney, we have to be really quite careful. We have to check the company's articles, make sure there's something in there that's actually going to prevent that from operating as intended. It's quite common for company articles to automatically remove directors who lack capacity. So it doesn't in that case matter if you've got a power of attorney in place, you'd be gone. So we check that, and in some cases work with our corporate team to amend the company articles to allow the authority to be put in place should it be desired. As a slight get around to that, and a little bit less controversial, is when dealing with limited companies, you can instead give your attorney the authority, your authority as a shareholder. And what that does is obviously allows them to exercise voting rights. It is very useful where we have got a managed business. So if you are the sole director and shareholder and you lose capacity, ordinarily there's nobody there that can make decisions on behalf of the company, replace directors or anything else. With a power of attorney in place, the attorney can at least use their authority as in your capacity as shareholder, effectively, to appoint a replacement director, avoid the need to go to court, which is the alternative that if that wasn't there. So, very useful. Next topic is wills. So, wills come in a variety of forms and formats. I've picked up two in particular, which come up when you're trying to think through planning for the future, what you might be leaving behind, and in some cases actually thinking more about the beneficiaries than yourselves. So the first of those is wills that incorporate life interest trusts. And a life interest trust is a type of trust whereby you name a specific beneficiary who has the right to enjoy use of the trust assets, usually for their lifetime, hence life interest, but you have already dictated that on their passing, when that trust comes to an end, those assets will pass to a specific named person. These trusts come into play quite commonly with second marriages. So you can include a life interest trust that would provide for your spouse, so they can still enjoy the family home, enjoy income from any investments that you have. But on their passing, or if they surrender their rights in the trust, it will then pass to the children from the first marriage, for instance. The benefits of that are twofold. One, you can piggyback on spousal exemption. So from an inheritance tax point of view, it can be quite useful. With multiple families, there are a few things we take into account when considering getting them around. But from that point of view, there's no immediate charge of inheritance tax on the first death. And it also means that regardless of what happens in the survivor's lifetime, those assets that belong to the first die, we know exactly where they're going to go. They can't give them away. They can't end up having them taken into account. So care costs, for instance, and they, if they were to remarry, those assets are not matrimonial assets. They are in a trust that's outside of their control. So very useful option when it comes to particularly more complex modern families and planning around things like that. The other type is discretionary trust wills, and we love discretionary trust wills. They are the most flexible type of will. So a discretionary trust will looks a lot like gobbledygook. When you see it on paper, it says, I give my estate to my trustees with these powers to benefit any of these beneficiaries as they see fit. And that's it. But alongside that, we prepare documents called the letter of wishes. And the letter of wishes is not a legal document, it is guidance, and it sets out to those trustees that you've given them these trust assets, but what I'd really like you to consider doing is the following. And you set out there who you want to benefit, in what amounts, any considerations you'd like them to make when exercising their discretion that way. The flexibility point, which is what the first bullet point gets at, is because the letter of wishes is effectively what tells the trustees what to do, and it is not a legal document, you can redo that yourself at any point when your circumstances change, when the beneficiary's circumstances change, without necessarily having to come calling back to us and paying us a whole lot more fees to update your will. It allows quite a lot of movement, and particularly where you've got beneficiaries with changing circumstances, a really good way of catering to those differing needs and letting the trustees know what your thoughts are at any given point in time, while still allowing the flexibility to do whatever is most appropriate and potentially most tax efficient at that point in time. It is particularly useful when you've got vulnerable beneficiaries. So anybody who is financially vulnerable, potentially suffers from a disability of any form, you're just generally concerned about handing them large swaths of cash and how that will then be used. The beneficiaries will, the trustees will then have discretion as to how to pass funds to that beneficiary, whether to pass funds to them at all, in some cases, or whether to just use those funds to purchase items for them, help improve their lives without necessarily giving them cash that would either be to their detriment or they potentially blow. Very, very useful where you've got beneficiaries in receipt of means tested benefits. If you do have beneficiaries in receipt of means tested benefits, should they receive a large sum of cash from inheritance, likely means they will lose those benefits. Not necessarily a problem if they're receiving quite a large inheritance, but it is a problem if they're receiving a modest inheritance, because effectively what would happen is they would lose their right to means tested benefits. They would then have to use the inheritance to pay for their day-to-day costs, which usually disabled beneficiaries, and the cost of living is higher as a result. And they'd have to use through all of that before they hit the minimum amount and then reapply for the benefits from scratch. So it can cause quite a lot of difficulties for them. Discretionary trust allows the trustees instead to give them funds or use the money in a way that won't impact their access to those benefits, just improve their lifestyle. And the last point of discretionary trust, which is why we do really like them, it allows for tax planning in the next generation. So it doesn't really impact or change tax position for your estate. But what it does is it allows the trustees to loan money to beneficiaries rather than give it to them outright. And by doing that, they've created a tax deductible debt in that person's estate rather than a taxable asset. So when that beneficiary passes away, that debt is repaid to the trust rather than being in their estate and taxed 40%. And the trustees, on recalling that loan, can then pass it down the line to the next generation. So very useful. There are tax implications of having funds in discretionary trust, but for a long period of time, there is a 10-yearly anniversary charge to inheritance tax, but at a rate of 6%, so significantly less. And it's a good way to, one, protect the assets, keep them within the family, but also pass them down the line in as tax efficient manner as possible. Next one is lifetime gifting. So we get asked about this quite a lot, actually, and people often ask, is there a limit on what I can gift? That 325 figure is often in their heads. The answer is no, there isn't actually a limit if you're giving it outright. You can gift away £1 million outright, and you do not pay tax on that unless you die within 7 years. If you survive by 7 years, it's outside your estate. So that's where the 7-year rule comes into play, and it's the two that often confuse people. 7-year rule applies to any gifts made within 7 years of the date of death. Those gifts are brought back into account when looking at your inheritance tax position and reduce the inheritance tax allowances that are available to your estate. So the gifts themselves aren't necessarily taxable unless they're over the 325 threshold. And even if they are, if you swap them by more than 3 years, the amount of tax that's paid is slightly reduced. So if you do have the money and it is something generally being thought about, definitely take advice, but lifetime gifting and moving that money outside of your estate as early as possible is a good idea. Trusts do complicate things when you start bringing them into play in lifetime gifting, and they can actually, in some circumstances, extend that 7-year rule to a 14-year rule. So if you are considering gifting in lifetime trusts, very specialist point, please do come and see us. Quick reminder at the bottom about the exceptions that are available for lifetime gifting. So £3,000 per year annual exemption. If you gift up to £3,000 a year away, it doesn't come into account, it doesn't reduce your inheritance tax allowances. HMRC might have to keep a note of it, but it's not going to reduce the allowances available to your estate. Small gifts allowance, they really do mean small gifts, so around £250 for most beneficiaries. There are circumstances where that can be slightly more. So I think a child on their wedding is £5,000. You can gift them without that being taken into account either. Entirely up to you whether you think that's particularly generous or not. Thank you. And then the last one, which is very valuable, is regular gifting onto surplus income. So there is an exemption that says that if you do have surplus income, you can gift away as much of that surplus income as you'd like to in a tax year, without it being reducing your 325 threshold or the 7-year survivorship rule coming into play. Depending on how much income you have, that can be very good. HMRC as a result do look into these very carefully, but it is something where if you do have surplus income and it's the kind of thing you want to consider, what we would tend to do is give you the inheritance tax schedule that your executors would be expected to complete. And that sets out the sources of income that HMRC is expecting you to consider, sets out the sources of expenditure that they're also expecting to consider. If you can get to the bottom and get a positive figure, that's great. You can give that away. So very useful. Again, if it is something you're considering, you can speak to us. Last point on this one for me is gifting by attorneys. So I think this might come a little bit later with potential caterer Duncan. So can attorneys make gifts under last of power attorney? Yes, they can, but in limited circumstances. So attorneys are allowed to continue to support any charities or good causes that you have either historically done or that are clearly very closely affiliated with you. They can also make gifts to friends and families, but only on special occasions and only of a reasonable amount. And the term reasonable amount has been subject to quite a lot of litigation. It varies depending on the size of the estate and the expenses that that person is expected to incur, but it's a very tricky amount. One case did specifically say if you can stick within the small gifts allowance and £3,000 per year, that tends to be quite safe. Anything over that, you really do need to consider it. And as a general rule, we tend to suggest that attorneys are considering making large gifts. You apply to court protection specifically for consent to do that. That protects the attorney more than anybody else. It means they do have express authority. Can be very useful again in terms of trying to do tax planning in someone's estate when they lack capacity. But it is, again, a non-specialist topic. So if you do find yourself in a position where you are looking to make large gifts as an attorney, and nobody else is, yes. So I'm going to hand over to Kate, and she's going to run us through Eximius care and tax codes.
Good afternoon, everyone. Lovely to see so many people here. This is quite a dry topic, I'm afraid, but I will try and make it as interesting as possible. I always say to people, no one grows up thinking, I can't wait till I have care. I'm really looking forward to it. It's one of those things that you may get into a situation where you do need some care support or you want it for your loved one, and it's really important that you make the right decisions. I also say to people, please try and prepare beforehand. So we get a lot of people coming to us in a crisis situation. You know, maybe their parent has had a fall or their partner is coming out of hospital and they don't know what to do. And unfortunately, when we're in that sort of a situation, we don't always make the best choices and we don't always have the most information. So what I'm going to try and give you here is just a flavour of the sort of things that you probably need to think about. I'm going to give you a quick background, just who we are, because it's my business. So our name is Eximius, which lovely lady has already asked me what that means. I was trying to be far too clever. It means exceptional, and that is what we try to make sure that we provide. We only do live-in care, and I'll go through the different types of care and what you might be looking for in the future. But we do cover nationwide. For some of you who may have relatives or family members elsewhere in the country, we do go all over the country. I put that means exceptional. I've jumped the gun. We are a fully managed service, and I will get to that as well. But what that means is we are registered and regulated by the Care Quality Commission, and that is very important for some people. And I'll explain it. When the Care Quality Commission comes and rates care companies, they have 4 different ways of regulating them and awarding them. There's outstanding, there's good, there's requires improvement, and there's immediate improvement. We're very proud that 2 years ago we were rated as outstanding, and only 5% of care companies are rated as outstanding. I would say if you are looking at care options, good is still very good. If I were looking for care for someone, good or outstanding is what I would be looking for. We consider ourselves a bit of a personalised boutique type company because we have the luxury of just doing live-in. We spend a lot of time with our clients, a lot of time going into their choices, what they want, how they want to receive their care, and that's the sort of company we are. There are lots of very different companies out there, and it's up to you to choose what company is right for you if you were looking for that type of service. The main criteria is to bring in the sorts of things you need to look at when you're looking for care, either for yourself or for your loved one. So this is Dawn Jackson, who's our registered manager with one of our clients. She actually made him I think it's a queen of puddings, took it around him. So there are several different types of care. The easiest one is rehabilitative and respite care. And that is really, if someone's coming out of hospital, maybe they've had a hip operation or can't look after themselves when they get home, you can put in place short-term care just to get that person back on their feet and make sure that they're safe and looked after until they're ready to resume their normal sort of activities themselves. Respite care is slightly different, although I'm not really sure they are. That may be if you have a partner who you can't leave alone, but for whatever reason you need to go away, maybe you need a break yourself. And we always say that it's the care person actually looking after the other person that is often the one we look at as to how safe are they and how much are they taking care of themselves. And you can put in short-term, 1 week, 2 weeks, 3-week care just to get you through that period. There's then nursing care, care home care that most people know quite a lot about. I have never done care home care, so I will tell you from my perspective why you might choose it, the pros and cons of it. But certainly if that's something that you were to look at, you need to go and have a look at different care homes and see how you feel about them. And there are all sorts of organisations that can help you with that. There's what we call domiciliary care, which is your short calls. That is someone having it can be anywhere from 1 up to 4 calls a day, or maybe a couple of calls a week. It can be 15 minutes. Unfortunately, if you're getting care from the local authority, it probably will be 15 minutes, up to several hours. And that can be for all sorts of aspects of care that you need. And again, I'll go into the pros and cons of that. There's then live-in care, which is what we do. I was in domiciliary care for 15 years. I obviously am very passionate about live-in care. So live-in care is where someone goes and lives in the house with your loved one, with yourselves, and can be there. My mother actually has vascular dementia, and she has had a live-in carer for 5 years now. So, and it's always been the same carer. She takes breaks, but it's always been the same carer. So that can work really well when you're looking at a long-term situation that needs a lot of support. And then finally, and I will talk a little about this, is a sort of PA arrangement and an agency arrangement. So there are lots of companies out there that will provide you with information on carers, and you recruit them yourselves, really. You are their employer. And for some people, it gives them a lot of choice, a lot of flexibility, and that's what they want. So very quickly, going to go through the pros and cons of each one, because these are the sort of things you need to think of when you're looking at what sort of care you want. So a pro of a nursing residential home is obviously it's 24-hour care. There's always someone on site at any time. If you need that support, it's there. In most cases, a very good bank of well-trained staff who are there to support you. Very sociable, and for some people that's really important. They want that interaction, they want to be part of a sort of commune type living. And I haven't actually talked about retirement homes and villages, but that sort of falls into this area for me. Cost, very variable, very variable. So anywhere from about 650 a week up to, you know, certainly one of the big chains in this area, 2,000 a week. So that's the sort of cost that you might be looking at if you're looking at care homes. The disadvantages, obviously, we've had all the situation with COVID and infection control, and we still hear a lot of stories about care homes being closed, so you can't visit, you can't have any of your friends in, etc. So that's a consideration for some people. Lack of privacy. Some people don't want that socialization. They don't want to have to sort of become friendly with a whole group of new people. They like living their life the way they want to live it. It's very structured. So lunch is at this time, breakfast at this time, etc. So you lose the sort of flexibility that you might have if you want to stay in your own home. It's a pro and a con, I think, for couples. Some care homes are very good at providing care for couples staying together. Some are not, and you find that couples get separated and it's not the way that they want to live. Domiciliary care. So I've already mentioned this is sort of the shorter calls that you might need. So very flexible. You can decide what you need, what times, as long as you're not going through local authority, and what sort of things you want done within that time. Cost. It can be more, I won't say very cost effective because care is expensive, I'm afraid, but it can be more cost effective than a care home, than living care, than other things. And you can sort of switch it on and off. So you can decide that when you're not feeling great, you might need a half-hour call in the morning. But when you feel better, you can cancel it. So it's that sort of thing that works. You can retain a lot of your privacy. Unfortunately, care is intrusive, but because you've only got someone coming once or twice a day, you still have a lot of your own life and a lot of your own time. The cons against it, unfortunately, and I'm sure you're aware of this, there's a recruitment crisis in care, so the lack of continuity is not good. We've certainly heard horror stories of people having, you know, 4 calls a day and they're getting 28 different carers a week, which is not what you want. Well, it's not what I would want. Timing of calls, again, all tied into that. You might want to be up at 7 o'clock in the morning, and in fact, you'll find that no one can get to you till 10 o'clock, which again is not great for a lot of people. Missed calls, again, unfortunately, because of the lack of people, if someone goes off sick, there is a chance that your call will not be done. And some people get very anxious by that, which I totally understand. And especially if it's a critical call, that's not a good situation. So if you are vulnerable, that, you know, might not work particularly for that person. Living care. So the pros of living care, consistency. I've already mentioned to you my mother, she's had the same carer for 5 years. We always try and make sure that when you have a carer that you like, they stay with you. So they can stay with you for anywhere, you know, 2 to 3 to 4 months, and then they might take a break and you'll have another carer, but it's very consistent. It's one-to-one care. I put in brackets 24-hour care because of working time regulations, etc. So while they are there all the time, they work approximately 10 hours a day. You can retain your privacy. It's very personalized to what you want. We have a whole range of clients. We have some that just want companionship. We have some that need a lot of support. And we do quite a lot of complex care, so spinal injury, brain injury, that sort of thing. And it's really important that you keep your privacy and your dignity when you are being cared for. Very good for couples living care and much more cost effective than a care home where you'll be paying for 2 people, but normally with living care, it's a slightly higher rate than for 1 person. And you build a rapport. My mother's carers, a friend of ours now, you know, that's what happens if you want it to happen. Doesn't, not everyone wants that, but you can build a really lovely relationship. We get some wonderful stories, don't we, from carers and what they're doing with their clients and the sorts of things that they're helping them with. So that can be important. Oh, what about them? Oh, there we go. The cons. I didn't want to share them with you, obviously. Cost. Care isn't cheap. I've already said that, unfortunately. Look at the type of company you're looking for. You're probably looking at anywhere from 1,000 to 2,000 a week for living care. You're sharing your home. That's a big deal for some people, especially if you're actually not the one receiving the care. If you're a partner or a spouse and you've got someone else living in your home, that's very difficult. And that's where companies like us step in, because we're very good at managing that and picking the right people. There is less flexibility. They are there all the time, you know. So if you have a day when you actually don't want care, you can to a certain extent change it, but it's not as easy as domiciliary care or somewhere else where you can just cancel it. Where's that gone? It's gone a different way, but that's okay. PA agency, so I did mention this, is where you recruit them yourselves, and you can use an agency to do this. So the pros are, cost-wise, it's much less expensive. If you were looking to do domiciliary care at the moment, you're probably looking at £25 an hour. If you were using a PA, you're probably paying £16, £17 an hour. So it's much less expensive. You have control and choice. So you recruit the people, you decide who you want to use, and that gives you that sort of impact. Very flexible. The cons can be very time consuming. So actually interviewing people and then putting them in place. And what you do find is people will come and work for 3 weeks and then decide they don't want to do it anymore. You're the employer, so you have all the employer issues. So in essence, you are responsible for holiday pay, for maternity pay, for all the things that go with that, should that happen. And there's no monitoring or management. So if that carer suddenly disappears on you, tough. You start again, you go back to the agency and you recruit again. So just in summary, some of the things that you should think about, obviously financial, we've got a wide scope of what is needed there. And if you are looking at it long term, it can be a really significant cost. Your own home, you know, if you want to stay living in your home, then obviously a care home is not for you, but it may be that you don't mind actually selling that home to help fund your care to do other things with. Social needs, my mother's always been quite a private person. She would hate to be in a care home. She never wanted that, always wanted to live in her own house. But certainly, as I've already said, I know other people that love the social activity of being in a care home. Flexibility, how flexible do you want to be? Do you want consistency? Do you want to know what's happening? Or are you quite happy to manage it yourself? Family and spousal arrangements, very important if you're living with someone else. What is the impact on them of what you're putting in place? And regulated versus non-regulated. I'll touch on that really quickly. So regulated is through the Care Quality Commission. If it is regulated, then we are checked constantly. We have certain policies, procedures, etc. we have to put in place. So you have no concerns. We employ the carers. We're responsible for their holiday pay, everything else. All you are doing is using us to manage that service. Non-regulated, there are no checks, whistles, etc. No police, that don't have to be. There are some very good non-regulated companies out there, but it is a consideration. And that's me, really. That was a shock. So I guess there are questions at the end, are there, if needed? Lovely, thank you.
Good afternoon. My name is Duncan. I'm the director of a local financial advisor firm called Premier Financial Management. We're based in Marlow. What I'm going to do this afternoon, Kate just mentioned there that you've got a whole raft of different care types. And I think one of the big variables with that question is around the financial aspect. How much can we afford to pay towards the cost of care? So what we're going to do this afternoon, I'm going to take you through 3 or 4 different scenarios that are recent real-life cases that we've seen in our firm over the last 6 months. It won't surprise you to know that care and later life planning is one of the biggest topics that we see at the moment. People are living longer, the cost of care is incredibly high, people are genuinely worried about it. And that really starts when people are in their 40s, 50s, 60s. So just by way of an example, this is a case study where a married couple, I don't know if you can see this at the back, married couple, both age 60, they're looking to retire. They have 2 state pensions of roughly about £10,000 each. That will start from 67. They've got a final salary pension from 65. They've got about £50,000 in savings, £100,000 in stocks and shares. That's an ISA. They've got £500,000 in pensions. They consider themselves to be moderate risk investors. They're prepared to take a bit of risk with some of their money. Their objective towards retirement is they've told us they want £4,000 a month net after tax until the age of 80. Then they think they're going to slow up a bit. So from 80 onwards, they want to budget for £3,000 net per month in today's terms. The way that we approach this typical scenario is we look at their cash flow, their future cash flow, based on a number of assumptions. And the first graph that you're seeing here is where is that money likely to come from? Where is that £4,000 a month physically going to be paid from? What you can see here, the blue bar at the bottom is the final salary pension. We know that's guaranteed. We know when it's going to start. The red and the yellow bars are the state pension. So that's all guaranteed income. It's going to pay for the rest of their lives, and you can make certain assumptions about inflation, but it's there, it's guaranteed. This green area that you see is the shortfall. That's the bit that isn't covered by their guaranteed income sources. So the obvious question is, where does it come from? And do the clients have enough of other assets to support that shortfall right the way through their retirement? So here, that's the £4,000 a month. They're spending that when they get to 80, it drops down to £3,000 per month. But there's always a shortfall. So based on a number of assumptions, what we do with our clients, we've got their ages at the bottom, you've got their liquid assets, so things like their personal pensions, their ISAs, their cash savings on the left-hand side. What we're trying to establish here is, do they have enough to see them through retirement? Do they have enough in assets to be able to spend all the things that they want to spend money on? And if you take an opinion in terms of the growth and you look at things like inflation, in this case, we were saying to the clients, you should be fine. You have enough money to be able to retire when you want to retire and to spend the amounts that you're looking to spend. No problems. In fact, we're optimistic at Premier. These clients are living to 100 and they've still got the equivalent of £500,000 available to them. So you could argue they have surplus assets that could be used towards things like inheritance tax planning. So that all looks fine. But what happens if there's a change in their circumstances? What happens, for example, if care is required? And in this case, it was the wife that we were looking at. And we assume that she would require care from the age of 80. The cost of care, as Kate was saying, broadly £60,000 a year is not unreasonable, certainly in these parts. We know that the cost of care increases at a higher rate of inflation typically. So we've assumed 5% inflationary increases. The wife then unfortunately passes away at 85. How does that impact on the surviving husband? He's still alive. He receives his final salary pension, but obviously he's lost his wife's state pension. So if we read on the analysis, that's them spending the £4,000 a month. Then you get this big jump in the cost of care, and then it drops down again to £3,000 a month from 85. You've got the sources of income, as we had before. The one thing that's obviously disappeared is the wife's state pension. So how does that then impact on things? Well, unfortunately, their liquid assets run out. They can't afford to cover that cost of care for 5 years. Still got the house, still got state pension, final salary pension. So what can we look at for them? What alternatives do they have? Well, the first, and I'm sure that most of you will have heard of this, is something called equity release. Equity release is essentially you releasing equity from your property. For most of us, our property is the biggest asset that we will own. It will be the biggest part of our estate. We can effectively take out a loan against that property. We will be paid a capital lump sum in exchange. We can use that capital that we've released to bridge the gap between our expenses. Equity release used to be frowned upon. These days, it's quite a common part of financial planning. It's regulated and it's widely available. But there are advantages and there are certainly disadvantages. One of the biggest advantages is, again, as I just said, for most of us, it's about converting one type of asset into another type of asset. In this case, equity from the property into income or capital. You can stay living in your own home. That could be really important if you take Kate's view, which is you want in-house care, perhaps. It can reduce your inheritance tax because you're taking out a loan. That loan will need to be repaid in the event of someone's death. So you could see it as saving 40% inheritance tax. And these days, most of the equity release arrangements that we see are portable. You can move it from one property to another property if you decided to move. The disadvantage is it might not give you enough in terms of what you need, and it might not reflect, the amount that you're raising might not reflect the full value of the property. These things can be quite expensive. There are setup fees. You've got arrangements, legal valuations, plus there is interest rate risk. Haven't been able to say that for the last 10, 15 years. But if you look at equity release plans at the moment, typically you're looking at an interest rate of about 7.5% to 8.5%. That debt or that interest obviously rolls up for every year that the loan remains outstanding. The loan typically is repaid either when the house is sold because somebody's moved or the person has passed away. So it can accumulate. It can mean that the remaining family are left with a smaller inheritance because you borrowed against the property. And it may impact means tested benefits, which is the point that Ashley was making earlier. So it's not for everyone. But in this case, the clients could release £200,000 of equity from their property, put that into either savings or an investment, and it meant that for this particular client, that was enough to see them comfortably through for the rest of their retirement. So they were quite pleased with that. What about clients that don't have a property? Perhaps they've sold it already to help towards the cost of care. This is a different case, but again, a very common case. This is an 80-year-old widow who now requires care. Their home has been sold. They've got 750,000, which is in the bank. Their income is a 10,000 state pension and a 10,000 final salary pension. And the cost of their care is going to be about 70,000 a year. They're 80. We're assuming that this client passes away at 95. That's quite a long time for care. We would typically suggest that the average care is anywhere from 3 to 5 years, but the clients wanted us to work on a very worst case basis. So with minimal income and 70,000 care fees, how do we use that 750,000 that's now arrived in their bank? Well, we could. We could keep the money on deposit. We could keep it in cash. Safe, pretty much guaranteed. But with the inflationary increases that we tend to see with care costs, there is the danger that that cash could run out before they needed it. All right, so there's a risk there. What about if we invested some of that 750,000? So what we would typically say to clients with that sort of amount of money is you want to keep a sensible amount in cash and available, maybe 2 or 3 years worth of care fees, but the rest of it could be invested. Idea being that you're generating more of a return through that investment structure than you would if you simply left all of the money in the bank. So yeah, in this case, again, based on certain assumptions around how much growth we'll get through that investment. It could work out. They could have enough money if they were prepared to take a bit more risk and invest some of that 750,000. But we've all seen what's happened to the stock markets this year. There's no guarantee with that. You know, those assets could run out because of any sort of crisis that we see, a stock market sell off, and you're back to square one. So for those clients that don't want the risk of an investment strategy, probably aren't going to meet their income needs through keeping the money on deposit, they could consider buying an annuity, a long-term care annuity. And essentially, what that involves is taking some of that 750,000 and exchanging it for guaranteed income for the rest of that client's life. The income that's generated, or the annuity, as we call it, is then or can be paid directly to the care home. Stops them having to worry about covering the cost of care. Still means in this case that there is cash available to the family or to the client should they need it. In fact, for this client, the shortfall between their income and the care cost was 50,000. We worked out that 300,000 could be exchanged. That would give them 50,000 a year for the rest of their lives. That money gets paid straight to their care home. So it means that they've still got 450,000 of cash available should they need it. It's safe, it's guaranteed, and it covers all bases. And at the moment, because of gilt yields and interest rates, annuity rates have actually picked up fairly significantly. So you're not having to give up as much capital to get that guaranteed income compared to, say, 12 months ago. From the family's perspective, thinking in terms of powers of attorney here, this would be your safest route. Because you know, whatever happens, that cost of care is now covered for as long as the client needs that money. From the family's perspective, it still means that there's a potential inheritance with the remaining funds that are available. All right, so in this case, you've got the pension income, you've got the 50,000 a year now coming in through the annuity. That green shaded area at the top is the difference between the annuity costs and the income sources because of inflation, but you would meet that typically from that 450,000 that you've left over. So there you are. In this particular case, the clients, yes, they see their assets deplete slightly, but there's still plenty of assets available. They know that they've got a guaranteed income and there is that future inheritance. Last bit from me, pre-funding care. Sometimes we get clients saying, well, how can I protect against future costs of care? I have to say there's very little in terms of products out there on the marketplace. There's no longer sort of long-term care insurance per se. So we would encourage you to think about the wider planning issues that we've just been through. Inheritance tax mitigation, we talked briefly about it today, but going through that sort of exercise where you're working out how much you can afford towards the cost of care, whether your assets are sufficient to cover those costs, can also lead on to other areas such as, can we afford to make gifts to the family and so on. Investment planning, yeah, are you prepared to take any risk? Do you have existing investments that are structured in the right way to cover the cost of fees? And obviously, for those that still have personal pensions, it's looking at your available allowances as well. So there are some other areas that are impacted by this, but those are the main areas. Hopefully that's been useful. And I'll pick up any questions later on. Thank you.
Okay, thank you all very much. Do you have any specific questions for Kate, Duncan, for myself? You want to ask?
I have a question actually for Kate. For any clients that might otherwise qualify, are you able to claim a contribution to your costs from local authorities? That sort of.
You can, but it's very, very limited. And there are different things. So if you have more than 23,000, someone might be able to help me with it. I think it's 23,950 or something in savings, then you are not eligible for support from your local authority. I will stress here, your local authority does have the obligation to give you an assessment, even if they're not going to help with your funding. And a lot of people don't know that and don't understand that and sort of think, well, I'm not eligible for funding, therefore I won't be involved with the local authority. But you may still want to, because they will come and do an assessment, and they do have to give you support and advice about equipment, support, whatever other things you need. The other thing to look at is something called continuing healthcare, which is, but it's very hard to get. And especially if you have a loved one that has dementia or something like that, it's very difficult. You have to go through certain criteria. We are not experts in actually finding that funding, so we point people in the right direction should they need it.
Great.
But it's not, there's not a lot of it.
Thank you.
Well, I just ask one question on the annuity that you mentioned. The annuity is taxable in your hands, isn't it?
No, it's unlike a pension, which it would be. This is paid tax-free straight to the care home.
So you avoid all tax on that.
Duncan, can I just ask?
Yeah, of course.
My understanding of it is, if I've got this
Yeah.
right, if you take out an annuity and they say we will pay for your care until you pass away.
Yeah.
If you pass away in the first year,
Yeah.
that money is gone. So it is a gamble. I mean, I like annuities, but it is a gamble.
It is, you're right. It's based on an life expectancy.
So they also say when you're going to, they would say when you're going to apply for one, do it when you've been ill and coming out of hospital.
Yeah.
Because their assessment is based sort of on life expectancy.
Yeah, absolutely. It's one of the risks of buying an annuity is that, again, from the wider family's perspective, that client could pass away very early on, and you've effectively lost that capital.
Yeah.
There are products out there that offer an element of guarantee. It says if death occurs in the first 12 months, you can get some of that capital back that you paid for.
But the annuity is not paid to you.
No.
So it's a deal that you go in that they will pay the care home.
Correct.
And the care home agrees that that will cover their costs, or is there a risk for them going up with their costs?
Well, I mean, there's always that risk of inflation and obviously care costs rising more than the annuity that you bought, which is why you would ideally either build into that annuity some form of inflation proofing, or you're using and making sure you've got available savings just in case.
And that's with a particular organization, it's not a general policy. It's an agreement with a particular institution.
Annuity from who?
Well,
Insurance company.
there are plenty of insurance companies out there that offer care annuities. Yeah. What you want to do, a bit like any other annuity really, is you want to look at who's offering you the best rates. But you have to be underwritten.
No.
You know, this is the insurance company will want to know how old you are, what your health is, before they make an offer of how much you need to pay them in exchange for that.
So the worse your health is, you get
The
best.
I have a property, shall we say, value 2 million, and I decided I'm going to give my relations the 2 million.
Yeah.
And they set themselves up as an equity company and do an equity release to me. Thus, avoiding inheritance tax. Why not?
So you've got 2 million, you're effectively giving away £2 million, are you?
No, I'm not, because I'm giving them the 2 million, but they're giving me an equity release of 2 million.
They'd have to set themselves up with the Financial Conduct Authority. But we've got a general saying in the firm, is it feels schemy. Probably
It's
is.
just an icky, that is
Feels
probably
So
wrong.
you're trading the owner of your house in that circumstance. So you give the house to someone and they're loaning the funds back.
And they're also guaranteeing that I can live in the house.
Fine, so that's a gift with the reservation benefits. Yeah. So I've never escaped the state inheritance tax. But if they then loan the funds back to you, you've done no inheritance. You've given them 2 million quid, they've given you back 2 million.
But they're actually, set them up as an equity release company.
Well, they would have to be regulated, as Ashley says, but I feel that's got an element of gift and
My
reservation. One of those.
understanding also is that the local authority, you know, if they're looking at funding and whether you are trying to
I'm not worried about that.
Okay, but in that situation too, I thought there might be a limit, like a 7-year limit, as to you gifted your money.
Yeah,
to
well,
avoid care costs.
but I
there is
haven't.
no limit.
I haven't gifted it because I have actually given it to them as an equity release, because they've got to purchase my house and let me live in it.
You mean they would have an equity release?
I think they would live at that.
Of course they would, but if, as my relations do happen to live abroad, I'm sure I can work on it.
That, what Alex says is absolutely right, though. I suspect we are nearing on to gifts with reservation, which is you still retaining some form of benefit from that gift. You're still living in that house.
No, there was lots of anti-avoidance around this. It used to be do sale and leasebacks, which were a classic 10 years ago, where you grant yourself a long lease in your property, thereby devaluing your freehold. You then ask a relative to buy the freehold at full market value, but it's devalued. And of course, when you've got the freehold out, no gift with a reservation, if they bought it at full market value, you yourself have a long lease and have guaranteed your occupation. The revenue caught on to that relatively quickly. So anything that's got, as Ashley says, an element of artificial step to secure a tax advantage. There are general anti-avoidance and targeted anti-avoidance rules that typically either stop them in their tracks, or you have to report just the revenue for their opinion, which will be poor. We like to have we always like to hear about schemes. I like a bit of creative schemes. So.
An amount of time where your equity release then will stop, or can it go on forever? But
Yeah, it will stay in place until effectively the house is sold.
Yeah.
Or the debt is repaid.
Yeah.
So.
And the debt doubles every 7 years or so at the present interest rate.
Well, that's a very good question. So a lot of people will say, well, what happens if we take the money out relatively early on in our time? You've got these horrendous rates of interest, cumulative. Is there a danger that actually the debt becomes worth more than the house?
Yeah.
And you're in a negative equity type of scenario. Most of the products these days will have a clause that says they will not apply a negative equity. So the worst that will happen is you give back the house.
There will never be an excess of the value.
And the other thing is, I talked there about releasing an amount of money. You can phase these things.
Yeah.
So typically, if you're 65 to 70, the company might offer you maybe 25–35% of your house as equity. You don't have to take that all in one lump sum. You can dip into it. Every time that you take out a loan, you're applied or you're subject to interest rate at that time. So if you were thinking of releasing equity now, yes, it could be at 6.5–7.5%, 8% maybe. But in 2 years' time, we could see rates as they were 12 months ago back towards 4 or 5%.
And who values the home?
The company lending you the money. Yeah, they want to know that it's not going to fall over.
Can I ask about the general pension market? I think a lot of my income comes from